Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I am able to cover a vast diverse range of matters. Matters ranging from immigration law matters, family law matters, criminal law matters. So whatever your legal questions are, please feel free to get in touch with us. Two ways to get in touch with us. First of all, you can call me on the landline number which appears at the bottom of the screen. That's the number which starts 01924, and that's to speak to me live here in the studio. Alternatively, you can send us a message, a text message, a WhatsApp message on the mobile number which also appears at the bottom of the screen. So mobile number is there for messages, and we get numerous messages that come in before the show, during the show, which is fantastic. So please do keep on sending those messages in. But as always, to speak to me live on air, not a problem at all. You can call on that landline number, which is there. A couple of minor points before we get going. Sometimes on a live show, it's not possible to take very detailed information from viewers who call in. If it transpires that your matter is complex, or I need to look at your documents before I can advise you properly, then I will ask you to leave your number with the control room and I will have a more thorough discussion with you off air. And this is a service that we provide here on the free legal advice show, completely free of charge. In my experience, the vast majority of questions which are put to me live on air, I will be able to give you some guidance in relation to those matters. And as I said earlier, we get numerous questions on immigration law, which is fantastic. Please do keep on sending your questions in. But even if it's a non-immigration law related matter, I will be able to give you some guidance in relation to those queries as well. Now, today, just before we've come in, we've already had 5-6 questions which have already come in. Please do keep on sending your questions in. So let's have a look at the questions which have been coming in just before we came on air today. Okay. Immigration law questions, fantastic. My area of specialism, so absolutely no problem giving you some firm advice in relation to the questions that you're posing to me today. First question, interesting question, regarding a viewer who's texted in regarding a daughter who is abroad. So our viewer is here in the United Kingdom and is asking a question in relation to the daughter who is abroad. And our viewer says as follows. Let me read the question out for the benefit of our other viewers who are watching the show today. Our viewer says, I am a British citizen and I live in the United Kingdom. My 18-year-old daughter lives in Kenya. How would I bring her to live in the UK? She has no visa. Interesting question. Now, what I do note here, and this is quite important, is that your daughter has turned 18 already. So in terms of immigration categories, the vast majority of immigration categories, European rules are slightly different. With the vast majority of immigration categories under which somebody is able to come to the United Kingdom, somebody who has turned 18 is treated as an adult. So the rules which relate to children no longer apply once the applicant, in this case the daughter who is abroad, turns 18. Now, the problem with that is that really limits our options. Because had you said to me, my daughter is under the age of 18, we could have possibly looked at how a dependent child could be sponsored to come to the United Kingdom, whether as your child or I don't know where the child's mother is, whether it's possible to make an application for both of them to come here. I don't know what the circumstances are, but to some extent that has now become irrelevant because the daughter has turned 18. So those child categories under which a child could come to the United Kingdom no longer apply. So essentially, you are looking at the 18-year-old as an adult, and you would really be looking at not a visa based on a child joining a parent, because the applicant is no longer a child. That's the problem. You are really looking at all the other categories which are opened to an applicant who is abroad. Now, typically, there would be a visit visa, which is not ideal because that's only a temporary visa. Child's 18, potentially you could be looking at a student visa to study at a university, or work visa. Those are the categories we're looking at. Let's take our next call and let's then come back to this question. Hello, अस्सलाम वालेकुम।
वालेकुम सलाम। अलियास भाई क्या ठीक हो?
जी अल्हम्दुलिल्लाह ठीक है, आप कैसे हो?
हाँ
ठीक?
अलियास भाई, एक क्वेश्चन है कि क्या कि आदमी की कंट्री में आता है तालीम हासिल करने के लिए, स्टूडेंट वीजे पर
जी
आता है,
जी
उसकी तालीम मुकम्मल हो जाती है, वो जो जिस कोर्स में आया था उसका वो कंप्लीट कोर्स हो गया,
जी।
तो क्या आगे उसको वीजा कैसे मिलेगा? वो उसको आगे की थोड़ा जा आगे सा थोड़ा
जी,
जा वो
तो
बताएं।
ये जो आपने कहा ना वो कोर्स उसने कंप्लीट किया, तो उसने वो डिग्री, मास्टर्स डिग्री जो भी है उसने हासिल कर ली।
कंप्लीट हो गई आगे, यानी उसका जो वीजा था ना वो खत्म हो गया, डिग्री कंप्लीट हो गई,
ओके,
तो आगे उसको क्या करना चाहिए?
जी जी जी, वो काफ़ी ऑप्शंस है। आगे
हम्म,
आगे भी काफ़ी ऑप्शंस है। अभी न्यू रूल्स आए हैं जिससे उसके
ओके
पास ऑप्शंस, अपॉर्चुनिटीज है। तो
ओके
भाई आप सुनते रहो, इंशाल्लाह मैं उसका जवाब दे दूंगा अभी।
ओके ओके, थैंक यू
और
वेरी मच।
जज़ाकल्लाह आपको कॉल के लिए, थैंक यू,
थैंक
थैंक यू वेरी मच। So our brother who's called in poses a very interesting question, a very relevant question. And the question is in relation to somebody who is here on a student visa. They've completed their course, they've got their degree, whether it's a bachelor's degree or a master's degree, they've got the degree. What other opportunities are there for that individual? Now, since last year, uh, the immigration rules were changed, and the Home Office has introduced a visa which is called the graduate visa. So, those who graduate in the United Kingdom, whether they have completed a bachelor's degree, a 3-year degree, or whether they've completed a master's degree, which may be only of 1 year in duration, it is possible for them to apply for a graduate visa, which would allow them to live in the United Kingdom for 2 years on top of their student visa. So, if the student visa finishes now in February, most of these student visas do come to an end then, it is possible to get a 2-year visa, which would take them to somewhere in 2024. Now, that is again a temporary visa, but the idea behind that, I think, is really twofold. First of all, it gives graduates, foreign students who graduate in the United Kingdom, the opportunity to get work experience here in the United Kingdom. So it's any kind of work that they want to do, they can do any kind of employed work. So it gives them that experience. Secondly, it gives them the opportunity, if they're lucky enough, if they're good enough, to go into the skilled worker visa. Now, if you manage to get into the skilled worker visa, what used to be referred to as work permit, or previously, just before this new scheme came in, what was referred to as the Tier 2 visa. Now it's a skilled worker visa, slightly different to what we had before, but the concept is still the same. It's you're living in the United Kingdom for work. So from the graduate visa, potentially you can go into this work permit type visa, which after 5 years does lead to settlement. So the options are there. Now, so I know the brother called in and asked the questions in Urdu. So let me just recap what I've said in Urdu. So भाई आपने जो पूछा था ग्रेजुएशन के बाद उसके पास ऑप्शंस है, वो ग्रेजुएट वीज़ा में वो जा सकता है, वो 2 साल की वीज़ा होती है और वो 2 साल यहाँ काम कर सकते हैं, और 2 साल में अगर उसको कोई वर्क परमिट की वीज़ा मिल जाए, जो स्किल्ड वर्कर का नाम है अभी, तो स्किल्ड वर्कर की वीज़ा अगर उसको मिल जाए तो 5 साल के बाद वो वीज़ा में उसको इनडेफिनेट भी मिल सकता है. सो द स्टार्टिंग पॉइंट ये है कि उसने ग्रेजुएशन कर लिया, डिग्री उसको मिल गई, तो वो ग्रेजुएट वीज़ा में वो अप्लाई करके उसको 2 साल की वीज़ा मिल सकती है। So hope that answers that question. As always, if you're not clear about the answer that I've provided, please do get back in touch. You can give us a ring or you can send a message on the mobile number and we'll have a look at your question, any follow-up questions that you have. Right, okay. Number of other questions coming in. Let's look at another question. I know we're going to be taking a break soon, so let me just read the question out and try and address it as quickly as possible. And then I'll address the rest of it after I come back from the break. Now, the question that's been posed is this, and I do apologize. We've had so many questions coming in. Right. Brother is saying, my name is Shakir. I want to know about my asylum application. The interview that I had was about 9 months ago, but I'm still waiting for the Home Office to make a decision. What should I do? The problem at the moment is normally after the interview, you would expect a decision within about 3-4 months. If you haven't got a decision, really, there isn't much you can do, except if you want, you can write to the caseworker who's dealing with the application. Normally, after the interview, they would have said to you, if you want to send some documents in, this is where you send it. That's the address that you could write to and say, look, you know what? My interview was 9 months ago. I haven't had the decision. Can you please let me know what's going on with my case? You can do that. But with all applications, there isn't really much you can do. If there is a delay on the part of the Home Office, apart from asking for an update, there really isn't much you can do. It just depends on how busy they are, how complex your case is. So you might just in the end have to be patient, unfortunately, and wait for a decision. Hope that answers the question. We're going to be taking a short break. We'll be back in the next couple of minutes. Shall I see you then? Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. And as always, you can continue to send your messages in on the mobile number which also appears at the bottom of the screen. We've had quite a few questions coming in, which is fantastic. But you can also speak to us live on air by ringing that landline number, which is also there, the 0124 number. Okay, next question that's come in, I think it might be from our Facebook page. Question from Marina. Interesting question. I was looking at this just before the break. Quite interesting, but I think there is a straightforward answer to your question. And it's to do with somebody who's here already on a spouse visa, a partner visa, and they're applying for an extension of that visa. And the question really relates to the income requirement, specifically for those who are self-employed. So that's the background. Let's have a look at the question and look at what the solution is. Okay, so I'll read out the question that Marina has sent in. Question is as follows. I and my partner are registered as self-employed. Last year, we worked as self-employed contractors, support worker, carers. From April 2021, I and my partner as working as a delivery driver, rider, again, self-employed contractor. Can you guide us? Does the change of profession or source of income affect our visa application for indefinite leave to remain? Our income meets the financial requirements. So interesting question. Never had to look at this question before. But what is being put to us is this, that when you apply for an extension of your visa or you apply for indefinite leave to remain, and you are self-employed, your partner is self-employed, So we're not talking about limited company income here. We're talking about somebody who's operating as a sole trader or a partner in a business. So in that situation, let's say you're applying now, you would show your income from April 2020 to April 2021. So that's the financial year, the UK tax year that you would be showing your income over, April 2020 to April 2021. Now, what our viewer is saying is that in that period, the period which the Home Office uses for assessing income, April 20 to April 21, they were working as support workers, carers. After April 21, which is now in this financial year, but we're not using this financial year to support the application because they look at the last financial year, April 20 to April 21. Now, anyway, the profession has changed. Instead of working as support workers or carers, now it's changed to working as a delivery driver stroke rider. Does it make a difference? Well, look, the rules only say that, well, two things. One is they say that the Home Office will look at your income in the last financial year, which is April 20 to April 21. It then goes on to say that you must still be self-employed, so you must have self-employed income. It doesn't say it must be in the same profession. It doesn't say that. So I wouldn't be concerned. I would submit the required documents for April 20 to April 21. And in terms of ongoing self-employment, it doesn't say ongoing self-employment in the same profession. It simply says send proof of ongoing self-employment. And for that, you would normally submit the last month, last 3 months of bank statements showing the income coming into the personal account, maybe circle it, etc. So you would show that income is still coming in. So my view is that there's no problem. Show your income April 20 to 21 with the profession you were in then, and then show your current self-employed income, even though that income is in a different profession. The rules don't say that it must be in the same profession. It simply says you must still be self-employed. And that's demonstrated by submitting a document from a number of potential documents. And what I normally submit in order to show continuing self-employment is the recent bank statement or last 2-3 months of bank statements, and circle the income from self-employment that is coming in. In my experience, I've never had the Home Office go into that in a lot of detail. In my experience, the focus is really, in terms of whether the income requirement is met or not, the focus is really on the income during the period April 20 to 21. That's what the focus is on in terms of documentary evidence, and I'll run through that in a few minutes. It's not focused on what you're doing at the moment. They simply ask for one piece of evidence that you're still self-employed. So that gives me the impression that you really need to meet the requirement over the April 20 to April 21 period. And I think from what you've said, you do meet that requirement. And the kind of documents you need to submit, off the top of my head, would be the accounts, the tax return, the SA 302, which is the tax calculation, the evidence of tax payable, tax paid in the following April 2021 tax year, business bank statements covering the same 12-month period if you have a business bank account, or personal bank statements if you use your personal account for the same period, April 20 to April 21, your UTR number, if your partner's the partnership UTR number. So that's the kind of documents you submit. In terms of current self-employment, submit your last, I would normally submit the last 2 months, 3 months of bank statements, circle the income that is coming in from self-employment. And that should be okay. Marina, I hope that answers your question. Thank you very much for that question. Quite interesting, quite detailed question that was put to us. Fantastic. Right, let's go back to a number of other questions we've had coming in. And we've had numerous questions that have come in, which is fantastic. Please do continue to send your questions in. And as always, you can give us a ring on the landline number as well. Okay, let's look at the next immigration question. Our viewer says, hi, I used FLRFP to apply for an extension under the 10-year partner route. But the application is asking questions relating to the financial requirement and the English language requirement as well. Is this normal? Understandable. I completely appreciate where you're coming from and your concern that you're applying under the 10-year route. It's the FLRFP application under the 10-year route. And, as our viewers who might have gone through this already will be aware, under the 10-year route, you don't have to satisfy the financial requirement, the £18,600 requirement, and neither do you need to satisfy the English language requirement. So why is the online form FLRFP, why is the form asking questions relating to finances and English when that's not relevant? Well, the reality is that's just the way the form is designed. So I wouldn't be too concerned about that. The way the form FLRFP and FLRM is designed, it does ask questions relating to finances and English. So if you're applying under the 10-year route, because you've got children under the age of 18 that you're looking after, and let's say you don't answer the questions, as in you say, I'm not working, or you say, I am working, but I've got nominal income. And then when you move on to the English language requirement, you say, I've not passed anything, I've got no test. It makes no difference to the outcome, because as you fully appreciate, the financial requirement and the English language requirement are not relevant under the 10-year route anyway. So it asks the question, answer it, it's asking the question. But in the end, it's irrelevant, because the rules relating to somebody who is on the 10-year partner, 10-year parent route do not require the financial requirement or the English language requirement to be fulfilled. So you're quite right. Completely understandable for you to raise the question. And even in practice, what we tend to do is when clients come in and it's not very clear what the financial situation is like, they might have not really been working, we just say to them, you know what, don't worry about it. In terms of the financial question, we're simply going to say you're not working. It's not going to make a difference. Or if they're working, we'll put down they're working. If they don't have documentary evidence, so they haven't got wage slips, they don't have bank statements, they don't have an employment letter, we say, don't worry about it. You don't need it. So even if you're working and your documentary evidence is a mess, don't worry about it. Answer the question properly, honestly, fully. But in the end, it's not relevant. And I think the question is this: if you don't have documentary evidence to back up what you're saying in terms of your income, it doesn't matter. Submit the application, because these applications are based on your family life with your child, whether you and your partner and your child are together or somebody separate but having contact with the child. It's based on the child and the child alone. It's your family life with the child, living whether in a situation where you're living together, or whether you're having contact with the child. That's what determines whether the application is successful or not. It's not finances, it's not English. Those two factors are completely irrelevant. So to sum up, don't be concerned. You're not doing anything wrong. So do answer the question accurately, fully, honestly. If you don't have documents, don't worry about it. it's not a problem. But you're not doing anything wrong. Hope that answers your question. As always, if you're not sure about the answer I've provided, do please get in touch with me again and I will try and assist you as best I can. That takes us to the next break. Inshallah, we'll be back in the next couple of minutes. Inshallah, see you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please ring on the landline number which appears at the bottom of the screen. As always, to send us a message, and you have, thank you very much, been sending loads of WhatsApp messages. You can do that by sending the message through on the mobile number, which is also there at the bottom of the screen. The method of sending a message to that mobile number has become very popular indeed. But as always, you can give us a ring live on air on that number. Let me read the question out. Our viewer says, Assalamu alaikum. I'm a single dad of a 7-year-old daughter who is a British citizen. I'm on the 10-year route on a parent visa. I'm divorced by my wife and I've got married again in Pakistan. And I have made an application to sponsor my wife to the United Kingdom. So this is the second wife. What are the chances of her getting a visa just because I have limited leave to remain in the United Kingdom? I know I can't apply due to my visa being limited leave to remain type visa. I have attached the court order and also a letter from the social worker as well. Please assist. The dad is looking after the daughter who is 7 years old and who is British. Dad has a visa under the parent route, under the 10-year route. So after completing 10 years in the United Kingdom, 10 years possibly legal residence in the United Kingdom, dad would qualify for indefinite leave to remain. But what he's done is obviously separated from the first wife, got married and made an application for the second wife to come to the United Kingdom. The difficulty, and our viewer has identified the difficulty himself. The difficulty is that a brother who's texted in only has limited leave to remain in the United Kingdom. And I think you appreciate the difficulty that you're in. I can tell that from the question that you've put to me. And your concern is over the limited leave to remain, you having that and that aspect of your wife's application. Now, as you've probably been advised, if you're in the UK and you want to sponsor a wife here to the United Kingdom, you would normally need to have British citizenship or indefinite leave to remain or refugee status in the United Kingdom. I think humanitarian protection may be acceptable as well. I'm not sure on the last one. The difficulty we have here is that you only have limited leave to remain. My concern is, and I would say, and I can't say with absolute certainty, but I would say that the application is likely to be refused. So what the Home Office, in terms of the way it's assessed, what the Home Office, the immigration caseworker would do is would look at whether you fit in to the rules or not. So wife's application would be considered under Appendix FM of the immigration rules, which sets out what the status of the sponsor, your status, has to be. And what they will then say is, look, the requirement as to your status having to be somebody who's British or indefinite leave, etc., that requirement is not fulfilled. So what they will then look at is whether it's an exceptional case where that requirement, even though it's not fulfilled, whether the application should be granted as an exceptional case. Now, I accept what you're saying, that you have a court order, and you have also submitted a letter from a social worker. And I don't know what's in the social worker's letter. They will consider the contents of both the contact order, which confirms that the child has to stay with you. And I'm guessing, but there must be a reason for that, and the social worker involvement. So there might have been some difficulty in your former wife being able to look after the child. I'm guessing that that might be the case. So the Home Office will look at those aspects, will look at what the social worker says. It might be that the social worker has said that, if your wife is granted a visa to come to the United Kingdom, that will be better for your 7-year-old daughter as well, in terms of having a more stable family environment. And I completely understand all that, and I understand what you've done and why you've got the letter from the social worker. Maybe even a letter from the school could have helped. What are the chances of the application being considered effectively outside the rule, being considered as an exceptional case? In my experience, it's very rare that the Home Office would consider these kind of cases as exceptional enough to warrant a visa being granted to your wife who is in Pakistan. If you said to me, what percentage chance do I have of this case being regarded as exceptional? And I don't have all the facts, but I can sort of guess what the letter would say. I would put your chances, unfortunately, at the lower end, possibly around 10-20% chance of being granted a visa. Certainly not at the 50-50 mark. Now, that's my realistic assessment. I understand your situation, understand what kind of evidence you might have presented to the Home Office to support your wife's application. But as you appreciate yourself, you are really asking the Home Office to consider your wife's application outside the rules as an exceptional case. It is very difficult to get those kind of applications to be granted. But you know what? It's worth a try. And I completely appreciate what you've done. I wish you the best of luck. And I'm hoping that you might come back to us in the next couple of months and say, you know what? I managed to get the visa for my wife. But you've done all you can. The only other sort of documentary evidence that I can think of that you could have submitted, I don't know what the other professionals would have said, potentially you could look at whether the school could say anything about your child's development and how having your wife here would help, whether the doctor could comment on the well-being of your daughter. I'm hopeful that she's fit and well. I don't know whether there's any, if there is an issue there, I don't know whether some medical evidence would have backed up your case. But they're the only other additional pieces of evidence that I can think of that you could have explored to support your case. So hopefully, I do wish you the best of luck. Let's see what happens. You've done what you've done, and I completely understand where you're coming from. But thank you very much for that question. Hope I've answered that question as best I can. Okay, let's look at the next question that's come in. Immigration question, slightly different. The question is, what is an ancestry visa? Can it be used for an adopted child I want to bring to the United Kingdom? Ancestry visa is something that you don't normally come across on a regular basis. You do occasionally come across ancestry visas. The situation with ancestry visas is this, that in order to successfully apply for an ancestry visa, it's normally a grandchild who is applying for an ancestry visa. And the requirement is for the grandfather or the grandmother to have been born in the United Kingdom. So it is quite rare. So it's normally, you go back basically 2 generations to see where the person was born. Let's see. So you look at where the grandparents were born. Was one of the grandparents born in the United Kingdom? If a grandparent was born in the United Kingdom, then it doesn't matter where the father was then born, uh, and it doesn't matter where the grandchild is born. As far as long as the grandparent was born in the UK, it is potentially possible to apply for an ancestry visa for that grandchild who is abroad. So it really goes back to where the grandparent was born. The grandparent must have been born in the United Kingdom. So that's the basic situation. Now, so we don't have enough information on that front, that where was the grandparent born. Now, in terms of adoption, we don't have enough information about that. Now, it is possible for children who are adopted to have the benefit of the ancestry visa in the United Kingdom. So adoption doesn't mean that you're not allowed to apply under the ancestry visa, but you've got to trace it back to your grandparents. There has to be a formal adoption, but you then trace it back to the grandparents, the grandmother, the grandfather. Were they born in the United Kingdom? Now, if that is the case, adoption isn't a problem. And if you're the adopted child, if you're 17 years or over and you've got enough money to support yourself, then potentially the child who's now 17 or over, the grandchild who's 17 or over, can come to the United Kingdom. So in terms of adoption, the adoption isn't a problem. Whether the grandchild has been adopted or the grandchild's father has been adopted, it doesn't matter. That doesn't break the chain. There has to be a chain back to the grandparents who were born in the United Kingdom. And it doesn't matter whether the children aren't biological children, as long as there was a formal adoption. So a slightly complex area, which in practice you don't come across that often. And even if you do, it's normally applicable to those who might live in South Africa, where the children born there, they're able to trace their roots back, or the grandparents can be traced back to being born in the United Kingdom. It might be in the 1900s or something. So applies mainly to South Africans. You come across this visa with Australians, New Zealanders, where grandparents were here maybe in the 1920s, 30s, 40s. They've gone abroad, they've had children there, the children have then had children, and it's those grandchildren who are looking at coming to the UK under the ancestry visa route. Taking a short break, we'll be back in the next couple of minutes. Shall I see you then? Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. To speak to me live on air, please contact us on the landline number which appears at the bottom of the screen. But as always, you can send us a message on the mobile number which also appears at the bottom of the screen. We've had numerous questions coming in. Just been trying to go through the questions during our break so I can answer your questions properly. Right, let's look at the next question that's come in. A European law question. We used to get loads of these questions whilst we were going through Brexit and we were leaving the European Union, and people had to apply for their pre-settled status, their settled status. We used to get loads of these questions many months ago. Now these queries seem to have died down. But okay, let's have a look at this question relating to EU law and UK, EU and UK immigration law. Question is as follows. I would like to ask the solicitor regarding my best friend. She lives in Finland. She wants to move to the United Kingdom. She's never been to the UK. My question is, can she apply? There's going to be some difficulty with that. Let me just take the next call and then I will come back to this question. Hello, Assalamu alaikum. Hello.
Hello, Assalamu alaikum, brother.
Walaikum salam, brother. Thank you for calling.
How are you, brother? You okay? All good?
Alhamdulillah, good. How are you? You okay?
I'm good, brother. Thank you. Yes, I got a question, brother. So actually, I had a fingerprint done, which was in London, but that has been cancelled, and I have done it in Peterborough. It's outside London. So my question is, if your fingerprint is outside London, does that make your ID can come a little bit quicker?
No, it
Or
doesn't.
it's
It
not?
doesn't, brother. It's wherever you do your fingerprints, Peterborough or London. Once you do your fingerprints, the processing then starts now after that. So it doesn't really,
Okay.
it doesn't really matter where you've done it. Now, to give you a rough idea, once you do fingerprints, you should get the card within 2, 3, 4 weeks.
3-4 weeks, yeah?
Yeah, I mean, we've had the Christmas break. That obviously that slowed things down. But when did you do your fingerprints?
I have done it on 15th of December, so probably I will get it end up by this month.
I would have thought so. I mean, fair enough. 15th of December, a week later, we had the Christmas break. We've got a problem
Yeah.
with COVID. People aren't coming into work at the moment because they're self-isolating, so that's slowing things down. Fair enough. I would guess that you're looking at getting the card mid-January, worst case end of January, I think.
Okay, so mid-January or maybe it end up
I
January.
think so, because there's nothing else to do. I think your case is concluded. You've been asked to do your fingerprints. What else is left? I think just for your card to be printed and dispatched. Takes a couple of weeks. I mean, okay, we've had Christmas. So mid-January, end of January latest, inshallah.
Okay, thank you, because I can't hear you very well, but I will watch it later what
Ji,
you said
ji.
on the TV.
No
Anyway,
problem.
one more question, please. Yeah, sorry about that. Also, if I travel for apply for the travel documents, do I will get before the car travel documents, or it's not possible?
You should wait for your card
I got
first.
refugee status.
Yeah, you should wait for the card because they will ask for the information about your card when you apply, like the card number they will ask for.
Okay. And how long does the travel documents please take to
Travel
come? How
document
long does all
is
the
taking a
process?
long time. Travel document is taking around 5 to 6 months at the moment.
5 months, yeah?
5 months at least it's taking a long time.
Oh,
There's no fast track for it.
okay.
Alright.
Is there any way if you do fast track, if you give some more money, is there any way?
Not on travel documents. There's no fast track.
Not on travel documents. Okay, thank you very much.
Thank you, brother,
I
for your call.
appreciate it. Thank you very
Jazakallah.
much.
Thank you very much.
Jazakallah,
indeed.
brother.
Okay, Assalamu
Take
alaikum.
care. See.
Thank you very much. I think we might have another caller waiting, so let's go to that call. Hello, Assalamu alaikum.
हेलो अस्सलाम वालेकुम
जी वालेकुम सलाम जी, thank you for calling.
जी मेरा नाम आयशा है मुझे एक क्वेश्चन पूछना है आपसे
जी जी आप लाइव है और जी आप पूछ सकते हैं जी.
ओके मैं ब्रिटिश सिटीजन हूँ और मैं अल्हम्दुलिल्लाह एक कंपनी भी रन कर रही हूँ मुझे ये पूछना है क्या मैं अपने बड़े भाई को जो पाकिस्तान में होते हैं उनको स्पॉन्सर कर सकती हूँ किसी भी तरह के उनकी नेशनैलिटी का कुछ यहाँ हो जाए वो 4 से 5 बार यहाँ आ चुके हैं फैमिली विजिट वीजा पे
जी.
लेकिन क्या मैं उनको या अम्मी को अपनी इस तरह स्पॉन्सर कर सकती हूँ कि वो यहाँ के रेजिडेंट हो जाएं रेजिडेंट
तो आपके पास जो बिजनेस है ना वो
जी
बिजनेस
जी
में
बिजनेस रन करी
जी कितने बंदे काम
लिमिटेड कंपनी
तो आपका जो बिजनेस है ना वो किस टाइप ऑफ बिजनेस है
सॉरी आपकी आवाज बहुत आहिस्ता आ रही है क्या पूछ रहे हैं आप
जी आपका जो बिजनेस है ना बिजनेस यूके में जो
जी।
बिजनेस है तो वो बिजनेस में क्या करते हैं आप
मैं ऑनलाइन सेल करती हूँ
ऑनलाइन सेल्स या इसमें
जी।
कोई एम्प्लॉइज है आपके पास
जी जी है
कितने
2
एम्प्लॉइज है
एम्प्लॉइज हैं फुल टाइम
कितने कितने एम्प्लॉइज है आपके पास
2
2 एम्प्लॉइज है अच्छा लोग अभी है ना एक ऑप्शन होता है वर्क परमिट पे आप लोगों को बुला सकते हैं मगर आई थिंक द प्रॉब्लम इसके बिजनेस है ना थोड़ा सा बड़ा होना चाहिए सो अगर बिजनेस में ज़्यादा एम्प्लॉइज है तो चांस होता है कि आप भाई को बिजनेस में बुला सकते हैं अगर जेन्युइन वैकेंसी है तो वही एक रास्ता है कि लेट्स से किसी के पास बिजनेस है, रीजनेबल साइज का बिजनेस है, इसमें वेकेंसी है, जेन्युइन वेकेंसी है, और लाइक मार्केटिंग एक्सपर्ट की कोई वेकेंसी है, या सेल्स की कोई वेकेंसी है, बायर की वेकेंसी है, जेन्युइन वेकेंसी है, और बाई के पास उसका एक्सपीरियंस है, तो फिर आप आपके बिजनेस पे उस पर पोटेंशियली बुला सकते हैं। आई थिंक द प्रॉब्लम एट द मोमेंट इज बिजनेस थोड़ा सा स्मॉल है, तो होम ऑफिस अगर देखेंगे तो हो सकता है कि होम ऑफिस ये कहेंगे कि आपको बाई को बुलाना चाहते हैं, रियली बिजनेस में कोई जेन्युइन वेकेंसी नहीं है, ये प्रॉब्लम है इसमें। मगर इसके अलावा और कोई ऑप्शन नहीं है। जो वो परमानेंट का जो है ना, जो फैमिली को बुलाना है परमानेंट पे, विजिट वीज़ा तो वो आते रहते हैं, इसमें तो वो परमानेंट वीज़ा नहीं मिलती है। वर्क परमिट का ऑप्शन है, मगर थोड़े से बड़ा बिजनेस होना चाहिए, और वेकेंसी वो देखेंगे कि ये जेन्युइन है या नहीं।
ठीक है।
सो लेट्स से कोई किसी के पास क्वाइट लार्ज कोई फैक्ट्री है, इसमें 30-40 पीपल काम करते हैं, वो बिजनेस में थोड़ा सा इजी होता है लार्जर बिजनेसेस में। स्मॉलर बिजनेस में थोड़ा सा ज़्यादा डिफिकल्ट होता है किसी को बुलाने के लिए।
ओके, ठीक है। थैंक यू
ठीक है
सो
ना?
मच फॉर
नो प्रॉब्लम है, थैंक यू आपका कॉल के
ओके,
लिए।
अल्लाह हाफिज।
Allah Hafiz. Thank you very much for your call. Thank you. Question about work permits, whether it's possible to sponsor somebody to the United Kingdom on a permanent basis. It is possible under the skilled worker scheme, but obviously there are requirements which need to be fulfilled. Business has to be sufficiently large to warrant, sponsoring somebody to the UK, and vacancy has to be genuine, etc. Okay. So just before I took the call, those two calls, the question that we had coming in was somebody who lives in Finland wants to come to the UK on a permanent basis. The problem is this. Okay, under the rules that existed up until 31st of December 2021, a European citizen could come to the UK as long as they came to the UK prior to 31st of December 2021. They could apply for pre-settled status in the UK, which ultimately leads to settled status after 5 years. The problem is you can't do that now. That scheme is completely closed. So whether you're a European citizen or you've got only residence rights in the UK, you can't come to the UK on a permanent basis anymore. And that's a consequence of Brexit. Free movement of people came to an end. And that means that in this situation, European citizens can't come to the UK anymore to settle in the UK. Likewise, British citizens can't go to Europe to settle. Now, if you manage to come to the UK on some other basis, student visa, skilled worker visa, that's fine. But the mere fact that you're a European citizen isn't enough anymore to be able to result in you being able to get a right to live and work in the UK anymore. It was the case up until 31st of December 2021. It's no longer possible. Thank you for that question. Okay, I know we're coming close to the end of the show, but I do want to get through as many questions as I can. Next question. Our brother says, Assalamu alaikum, my friend is on a student visa, sponsored a husband as a dependent. He's now on a work permit visa. Both of their visas, student visa, work permit visa, coming to an end in 2023. Friend is pregnant, expecting their first baby. The baby is going to be born before, obviously, the visa expires in 2022. Visa expires in 2023. The baby that's going to be born here, will the baby get British nationality? The answer is no. The baby can only get British nationality when the baby is born here. The baby can only get British nationality if the parent at the time of birth has indefinite leave to remain. So if either parent has indefinite leave to remain, the baby that's born in the UK is born British. So the parents don't have indefinite leave to remain. They may qualify for indefinite leave to remain in 2023 after the child is born. So let's say in 2023, the parents do get indefinite leave to remain. At that stage, the child doesn't automatically become British, but the child can be registered as British. So, in summary, because the parents don't have indefinite leave to remain, the child being born here is not British. Once the parents get indefinite leave to remain next year, the child isn't British, but you can register the child as British. The fees are about £1,000 to register the child as British. So that's the basic situation. Hope that answers your question. If you're not sure, it's slightly complex. If you're not sure, do get in touch with me again. Unfortunately, we are coming to the end of the show. Thank you very much indeed for all the questions, the viewers who called in, and all the questions that came in. I did try and get through as many questions as possible. Some were left. I do apologize, but Jazakallah for all those questions. That brings us to the end of the show. Inshallah, we'll be back next week at the same time.